There is a new DUI law starting July 1st, 2021, and it deals exclusively with marijuana. So traditionally, if you drive with marijuana in your blood, either active or inactive, meaning even if you're not high in Indiana, you can be charged with a DUI under the third way to get a DUI in Indiana, which is having a controlled substance in your blood, a controlled substance or a metabolite of controlled substance. The controlled substance has to be a Schedule 1 or a Schedule 2. Marijuana is a Schedule 1 in Indiana. And so basically, the law has been, if you drive marijuana in your system, even if you smoked marijuana in Colorado, even if you took a gummy while you're visiting a friend in Chicago, if you get caught and there's still some of that metabolite lingering in your blood, meaning you're not high, then it's the DUI. Now, a new law is starting on July 1st that kind of sort of addresses that. So here's a copy of that law, and you'll see, starting July 1st, it's going to be a defense to subsection C. That's the person that operates a vehicle with a controlled substance or metabolite in your blood. That's a C misdemeanor. Now it's going to be a defense to that C misdemeanor if, or the second part, which I've highlighted the added portion, the controlled substance is marijuana or metabolite of marijuana. The person was not intoxicated. The person did not cause a traffic accident, and the substance was identified by means of a chemical test taken pursuant to Indiana Code 937. So yeah, I just read the statute to you. You're probably thinking, Mark, what does that mean? Well, at quick glance, it seems to be like a good law for people that, you know, might have went to a conference in Vegas and chose to enjoy some of the devil's lettuce, or perhaps they visited some family and friends in one of the states that surrounds Indiana where marijuana is legal in some sort. So, you know, they danced with Mary Jane up in Michigan, but they came back here. Or, you know, they had some gummies in Illinois, and, you know, it's a month later, they're in Indiana, and they get pulled over for a DUI. And for whatever reason, the officer says, I want to get your blood. And they still have some metabolite in the blood. It seems like a good defense. Well, hey, you know, I wasn't intoxicated. You're pursuing this charge just under the metabolite portion of the DUI statute. This looks like, at first glance, it might provide a defense for that. Or even, I got a call this week where a gentleman got stopped at a DUI checkpoint, and they charged him with having a metabolite in his blood as for the basis of his DUI. This looks like that'll be a defense to that, at least at first glance. So basically, no one's arguing intoxication. Maybe you're speeding, maybe whatever, he stopped for a tail light or a checkpoint, but no one's arguing the person intoxicated. They're simply saying, hey, they didn't cause an accident, they weren't intoxicated, yeah, they had some marijuana in their blood, but it wasn't messing them up. It looks like it might be defense to those type cases. Almost all of my time every day is spent on drunk driving defense. And so looking at the statute, there's some problems. I'm going to tell you right now, it's not perfect. The biggest one is people are involved in accidents all day, every day across the great state of Indiana. You don't have to be high or drunk to be in an accident. You just don't. It happens all the time. Ask any police officer, how many accidents have you investigated? Hundreds. It's boring. Are people always drunk or high when there's an accident? They're going to tell you, no. So this statute, even if you're not high, you're not actively high, but you get into an accident, you're still going to be charged with drunk driving? That doesn't make no sense. How is that fair? Most scientists agree that if you have inactive THC in your blood, meaning you smoked or you ate a gummy or whatever yesterday or a month ago, most scientists agree that if you have inactive metabolite in your blood, you're not high. In fact, there's an actual law where you can operate a nuclear reactor with a certain level of metabolites in your blood, and it's not against the law. So that's the first problem. The second problem is, while this provides a defense to the C misdemeanor DUI, if marijuana is involved, it doesn't legalize possession. So you could see a situation where someone still gets arrested for possession of marijuana, but they're able to fight their DUI saying, I wasn't high. But yeah, I had marijuana in the car, but I wasn't high, so it's okay. It creates a weird little situation with that. Third problem is pretty big as well. I don't understand why the legislatures thought it was necessary to add a reference to Indiana Code 937. Indiana Code 937 specifically talks about chemical tests when a DUI involves a serious bodily injury or death. Like, wait a second, we're talking about the C misdemeanor, which is basically, you pull over for an equipment violation. You get stopped at a checkpoint, or the officer smells weed. I'm gonna get a blood test to make sure you're not high. And then, you didn't. I don't understand why they reference this 937, because if a DUI involves serious bodily injury or death, it's a whole heck of a lot higher than a C misdemeanor. So it doesn't make sense why they did that. It's super confusing when you go deep into the statute and try to figure out why. It doesn't make sense why they did that. If they did it on purpose, then it might only be a defense if a person has metabolite in their system but they kill somebody. But it's not a defense if they get stopped at a checkpoint and their blood is taken and they have inactive metabolite, or even if they have active, as long as they're not intoxicated. It doesn't make sense how they're doing that, and that reference is kind of confusing. But if anyone watches my videos, I love it when things are a little bit ambiguous, because in criminal law, if the statute's ambiguous, the defendant gets the benefit of that ambiguity. And so Supreme Court recognized that. When it's confusing, benefit the doubt to the accused. So the statute may not be as great as it appears at first glance, but there are a few things that are super clear. Don't drive after smoking marijuana or eating a marijuana gummy. Don't do that, because intoxicated driving is still a crime, and this statute does not afford a defense whatsoever to intoxicated driving. So don't think this is a get out of jail free card. You can hang out in the car, do whatever you want. That's not what's going on here. Don't drive while high. If you have any questions, give me a call, 317-632-3642. Blood DUIs are one of the most interesting things that I deal with as a criminal defense attorney. I could probably talk about it all day. So if you have any questions, give me a call, 317-632-3642. And remember, most importantly, always plead the fifth.